Go for it.
Hey, good morning, everyone. I'm Chris Parker with Chris Nishihara
Morning.
at the Ishihara Parker Law Firm here in Longview, Texas. And today we are covering the topic of adoptions. We are looking at two different scenarios. One, I have brought a child into my family. I have adopted a child. And the second scenario we're going to look at is I have given up a child or had my rights terminated. How do those affect my estate planning? Kristen, let's cover the first topic. We are adding to the family. What does that mean?
Sure. And I think the point we definitely want people to know is this is a conversation you need to have with your estate planning attorney. So if you have either of those scenarios, just make sure they're fully informed. The short answer to my child has been adopted. So you've adopted a child into your family. This can be done obviously a number of ways. You can adopt a child through like CPS, a Buckner, one of those services, but you've legally adopted the child. Sometimes that happens through a family situation. A child has been removed from another member of your family and you are caring for them. Here's where I'd want you to specifically talk to your attorney about this, because there is a difference between whether CPS has placed the child with you and you are their possessory conservator versus whether you've adopted them. So even if you are raising them in your home, unless you have gone through the process of legally adopting them and they've had their parental rights to their biological parents terminated, that would not be the situation that we're talking about. But if you have legally adopted, have adoption paperwork from a court, then that's what we're talking about here. And what is the answer for that child?
Yeah, absolutely. An adopted child is the same as a biological child. Once you take the process to adopt a child, they are your child for inheritance purposes. Absolutely. Right. And I know I see plenty of folks who come in and, they have a later in life adopted child to a family situation. They bring me their documents. Their will looks perfectly good. I am married to my spouse. We have 2 children. 2 biological children. Of course, that will was done before the adopted child was brought in. I would like to know that because honestly, I think your documents need to be updated. You need to say, well, I actually have 3 children, right?
Sure.
This will needs to be current. I have 3 children and I'm expecting my assets to be handled in a certain way. Families are complicated. I've seen many situations where someone has adopted a child and they want that child included. I have other times where there's people who have adopted a children and for whatever reason, they don't want that child included.
Sure.
Those are the times you need to update your legal documents. There's no automatic inheritance. Well, there is an automatic inheritance. You can change that, but your documents need to reflect reality. I have 3 children because I do. I adopted. That is my child. If all 3 are included, great. If one of them needs to be excluded, that needs to be listed, right?
Right. So why this matters is because Texas law will write a will for you if you don't take the opportunity to do it yourself. And so when you pass, your legal heirs at law are included, and that would include your biological children as well as your legally adopted children. You can take the opportunity to have a valid will that lists your family members correctly, and then leave it to whoever you want. So whether you want to leave a child something biological or adopted, doesn't matter. That's up to you, but you do have to take the opportunity to have a validly done will so that you have that correctly reflected. If you don't, what we want you to know is that your heirs would be your biological and legally adopted kids. There's a couple of other murky areas in here. Remember, legal adoption is I've gone to the court. That child has paperwork that says I've adopted them. Sometimes you update the birth certificate to have that correctly reflected. But there's 2 other times I just want to point out here that can create some murky areas. So make sure and talk about your family situation with your lawyer. Adoption by estoppel is something that a child can claim if you made people believe that that child was adopted, they thought they were adopted. Sometimes this comes up in a stepchild situation, so a blended family where a child believes or maybe was told that they were adopted. That is kind of an affirmative claim that they can make against your estate, so just make sure that you talk about those things. If there is a child that believes they were adopted by you, you need to talk to your estate planning attorney about that. Regardless, whether they were adopted by you or they were not adopted by you, that is a conversation you need to have. And sometimes that comes up in a blended family situation. One other thing that can come up is adoption of an adult. So let's say you did have a stepchild that grew up in your home and you do want to adopt them for all purposes. You can adopt an adult once they reach the age of 18, and sometimes that's actually easier to accomplish. If you adopt a child under the age of 18, their parental rights to their biological parents have to be terminated, and maybe for whatever reason, legal or emotional, nobody wants to do that. You can, once they're 18, they can give consent to you actually adopting them as an adult, and that's a relatively simple process. But those three things are important to talk about. Make sure you fully inform your estate planning attorney about what your family looks like, so that they can help you go through the steps so you can set up your plan the way that you want it.
Yeah, I don't care if you have great old documents. If a major life event like an adopted child has occurred, you're going to have to get it redone. You just have to get it redone, because if you don't, Texas law will affect the current wills that you have done. They may very well include that child when that wasn't your intent. If you have a major life event in adopting a child or bringing someone into your home and making them think they were a child or treating them as if they're a child, that's a major event. And you got to think over your life, and you've got to tell the estate attorney that. I mean, part of that, I've had many folks show up and say, I'm not quite sure if that is my child, right? Those are situations in which the estate attorney needs to know who's in, who's out, and who's a maybe, so that they can draft it correctly. If you do not, one, there may be a huge mess, and two, Texas law will do things that you did not expect.
Right. Well, there's just two things here. There's legal and there's emotional, right? So a lot of times people come in, I've been married for 40 years, we have 4 kids. Okay, if I took that at face value, I believe that you have 4 kids together. Well, no, I need to drill down and find out mom has 3, dad has 1, but we treat them all like our children. That's amazing, that's wonderful, but if mom has 3 biological and you have 1 and they're not together, then I really need to know so that I can correctly draft that. So don't feel like you're, saying anything you shouldn't or slighting the relationship. You are actually making sure that the child you love is provided for in the right way so that we have the information. But it does matter if they're with your biological child or legally adopted child or something different, because the law does not provide for a stepchild. It does not necessarily provide for somebody raised in your home. You have to take an affirmative step to do that if that's what you want to happen there.
Yeah, absolutely. Okay, well, let's pivot, right? This is where, first we talked about where we have brought someone in. What if we're in the opposite situation? What if we had, we were younger, we were, a minor, whatever situation, and we had a child, and that child was given up for adoption, right? Mm-hmm. That is no longer our child because our rights were terminated under a parental termination order. What happens then?
Yeah, so this is an interesting one under Texas law. So the Estates Code and the Family Law Code specifically talk about this. But let's say I biologically birthed a child. That child is mine still for inheritance purposes. So my parental rights have been terminated. That child has been adopted into a new loving home. They are, like we just mentioned, that family's adopted child. So they will inherit from that mom and dad as their adopted child. Mm-hmm. However, unless the termination rights order that terminated my parental rights specifically says that they will not inherit from me, they will also inherit from me as a biological parent. So it is important to include that and talk to your estate planning attorney about that as part of your plan. Even though I have given up a child for adoption, that does not mean that their rights to inheritance under me would automatically terminate. That either needs to be in the termination order itself, or, of course, it can be done through a will where you can include or not include them as you prefer. But that is something that you would want to talk to your attorney about and make sure that they're aware of.
Husband and wife been married for a long, long time. It turns out the husband had a child when he was 16. That child was given up for adoption. I meet that husband and wife who've been married for 35 years. I ask them how many children they have, and they say we have a total of 2, right? I dig deeper. Any other children I need to know about, that's when I'm needing the dad to speak up and say, hey, actually, when I was 16, I did have a child. That child was given up for adoption. I've had no contact for the last 35 years. I have no relationship. We need to know that. I need to know that because in the will, I'm going to put down for dad, I have 3 children, right? 2 are all 3 are biological, but that third child, that first child in this case, I am specifically naming them and disinheriting them and their descendants if that's what I want. I don't want mom to find herself in a blended family situation with an unnamed child. That is a difficult situation.
Right. The attorney is not the person to keep secrets from. It may be unpleasant, but you do need to tell anything you have information-wise about families so we can help make sure that your estate plan is crafted the way that it needs to. Because you do have competing interests here. Texas law will create something for you if you don't correctly do it yourself. So to correctly do it yourself, you need to just give all the information that is available to the attorney.
Recently seen these situations like people have but brought up, oh yeah, well this situation. I was like, oh my goodness, we need to make some changes. So don't be shy about it because we cannot fix what we do not know.
Yep, that's correct. Don't have an unintended consequence. It's not, it is confidential. It is simply between you and the attorney, but it does need to be correctly drafted. So be sure and get that done. Anything else you want to add?
Nope, that's it, really. Thank you.
Yeah, good. All right, we'll see you next time.